Thank you very much, Eden. Good morning, everyone. Thanks to Curry for inviting me again. We've done a lot of work with Curry and its stakeholders in our IP clinics. So what I am not going to do is do another definitions of IP, of intellectual property, sorry. In case you're wondering what we're going to do today. We're going to get to, hopefully, some of the things that the drivers that you need to take in consideration before and after. And I'm thankful to Mr. Maloney for giving me some new sound bites. I'm going to teach some of them things. Right, so some context. Where we are, we're currently within the Ministry of Legal Affairs. Our primary function is to grant intellectual property rights, specifically industrial property rights. We also have a mandate to promote inventiveness among citizens and to provide patent technical information. So that's our locus, why we could be here. So a lot of what we're talking about is in the context of what does intellectual property have to do with your business? For some of you, you may have never heard the term before, never used it, and you might say to yourself, I'm doing fine. Why do I need to bother myself with this thing? Maybe lawyers are involved and they're expensive. Not necessarily. That is not necessarily, you need lawyers, not the expensive part. All right. But it all comes down to at what point should you be looking at intellectual property? So we would normally tell you, ideally, for any business venture, and a good point is when you're just about to start, that's the first time you should be encountering us or interfacing with the Intellectual Property Office to figure out what do you have, what have you created, what can you own. So it could be the start of an IP audit or an assets audit. So your assets are not just the things that the bank will ask you for, but they could be intellectual assets, know-how, etc., that you might be sitting on, that you might be able to own. Or if you engage them in the course of your business plan, you should be seeking to own them before somebody else tries. And in some cases, you might be relying on somebody else's creations in your business venture. That means you might have to be seeking permissions. So there's some different layers at which you need to be considering these things. So we tell people, yes, check us before you start. Get going, and once you have your business fully hashed and baked and ready to roll, you should come and check us at the end of that process to see what have you actually created and what perhaps you might be able to seek ownership for. Because we meet lots of people who create things. Okay? What have you created? And so we ask, and those of you who went through the training or the boot camp, would we ask for your value proposition? What is it are you selling? And it's not necessarily the product, it's what is attached to the product. There's an emotional quotient, or it's a part of that, for everything that you're seeking to sell or provide. It's not just the thing you're seeing in front of you, there's a lot more to it. Who are you selling it to, when, where are your customers? That quote I'm going to steal is, TNT is your home base, not your home market. That's very true. Many of our entrepreneurs, they start something, then they realize, other people might want this. I should be looking at my foreign markets. And when it comes to intellectual property, you need to have started thinking about that when you started talking to us. And we will ask you, do you have any export ambitions? Because there are things that you need to do early in the game as opposed to too late in the game, because there's some strict timelines that you need to be aware of if you need to acquire rights in another jurisdiction. Besides the practical nitty-gritties, setting up businesses, getting translations, etc., to seek some types of rights, there are some windows that you need to apply for within that very strict timeline if you want to have rights. Because the downside is, if you don't apply for those rights, and you're locked out of the window to acquire them, that means somebody else can acquire them, may be able to acquire them in that other market. So that's the scary part. If you don't do it, somebody else might. We encourage people to think about intellectual property like having some land down in Moruga. The intellectual property is like the fence around the land, and you should go and check on it to make sure nobody's squatting there. Otherwise, you know the rules. If you don't check on it and somebody occupies it without you knowing or without you moving them in time, they can get to own it. So it's as serious as that, or simple as that. Right, so just be aware that you need to be aware of what you have, where you're going early in the game. Have some, as Cal was saying, some vision like this thing could go global. Right, start from there. And then that should dictate what you do next. Okay? Because we meet plenty of people with ideas. Idea. Now, if you think about it, it will work, but it needs some refinement. And that's why it's important to put it up and start working on it. Right now, I have a friend who's on a mission in Japan, and I told her, make sure you go and try the Japanese paperless toilets. It'll be a thrill. But everything starts off, everything that you have right now or that you see on the market that is a hit product or a hit service right now, when it started off like this. Nobody thought it was going anywhere. It was going against the status quo. Everybody thought, nah, and turn them down. And you look at, you speak to everybody who's launched a hit product and how many times they got blanked, you'll see that. And how long it took to get recognized or for it to hit the market, so to speak, for the market to catch on. It starts off like that. So, because it's important to know what you have, because we would say what you have defines what form of intellectual property you should be going for, what would apply to what you have. It could be stuff that you have created, or stuff that you need to license from somebody, or stuff that you cannot own. You need to know the limits, what you can and cannot own. And not everything is up for registration. And there are some forms of intellectual assets that you don't put in the public domain, such as your trade secrets. They're things that you need to keep off the table. You need to have an idea of what can I negotiate with and what is not up for negotiation. What is the crux of my business? Okay? Right, so because the type of intellectual property defines durations, costs, jurisdictions, and scope. I'll use my next slide to... Right, so some of these terms you might be familiar with, some maybe not. Most people have heard about copyright and related rights, and that relates to literary and artistic works. Photographs, paintings, music, software, architectural works, mass designs, all those, anything that's considered literary or artistic falls under copyright and related rights. And with that, you see how long does it last for? It lasts for as long as the author or the composer is alive, and currently up to 50 years after his death. So I mean, some of these creations, the rights are viable after you're gone. There are things that you can actually leave in your will or leave to your estate. We are currently in the process of extending this duration to life plus 70 years. So there's an amendment right now that's going to Parliament soon. So that has an impact for persons who have like serious catalogs of works. And we were looking at our older artists and Caisonians. Even after they're gone, the estates will still be earning an income, as we've seen from the estates of many famous artists who've passed away. Michael Jackson and some of our local Caisonians. Every time Kitchener's songs are played, there's a royalty that goes back to his estate, whoever that is. Still. And that will happen for until 50 years after. And once it's still alive, once it's still valid, when our new amendment kicks in, it will be extended a further 20 years. That's why it's important. Another important note about copyright and related rights is very important, is that these are automatic rights. These rights arise as soon as you finish creating something. You don't have to come to our office to fill out any forms, pay any fees. These rights arise automatically in Trinidad and Tobago and in every other country around the world that has signed something called the Berne Convention. So many of us have never set foot in Ukraine. You have rights in Ukraine, just like that. Now the problem is to find out if somebody in Ukraine thieving your song. Because there's nobody policing that for you. But once you find out, you can take action under, of course, Ukrainian law. Now, because these rights are not registered, you're well advised to take some steps on your own to secure them for yourself, meaning that you may need to approach a notary public and swear to an affidavit that I own these things. Long ago, people used to be advised to use something called the poor man's copyright. I don't know if you ever heard that term. You put your works into a sealed envelope and you mail it back to yourself. And what that does is that the receipts create a legally recognized date stamp that might prove at least possession at a particular date. Worst case scenario, if there's a conflict of creation, some courts may simply ask the opponents, demonstrate for me creative process. Which is why we advise creators, it might be messy, but try to keep your rough drafts. If you're working in a digital environment, resist the temptation to just overwrite the whole file. Create a revision 1, revision 2, revision 3. If you look at Microsoft's operating software, you'll see what build is being installed on your machines if you're that kind of techie. Because they do keep note of which build they put out on what date, right? They keep a running record. So that's an important note. It's automatic. It's enforceable in most countries around the world, and that goes both ways. The next important thing is trademarks. Trademarks or your brand might be the first encounter somebody has with your entity before they even meet you or experience your product or your service. They've heard, people may have heard, I heard there's a place or a thing or a service that I need to get. They hear about it. What does that brand convey to you? And there's a whole psychology of why you need to be careful in selecting these words for your branding. And it's beyond just words, names, and logos. The new trademarks law now accommodates non-traditional marks, we call them, which encompass sound marks, taste marks, tactile marks. So some of us may know some of these things from other people. So when you see an MGM movie, what comes on? The MGM lion, and you hear that, a roar. Every ad for T-Mobile, you hear some notes at the end. Nokia, Intel inside. If you're a gamer, Mario, the coin sound, those are registered sound marks. And recently, locally, we had, this guy Remy, Rembangshan, and what he says at the end of his videos, Rembangshan. I think I have it right. But you know why? We had to listen to the sound clip over and over to get the notes right to put it into the file. You can, if those are part and parcel of your service, your look, your trade dress, those are things that can be registered along with just the name, logo, catchphrase, slogan. And the interesting thing about this, trademarks, is that they last initially 10 years, but they can be renewed indefinitely. We will send you a reminder notice, and if you renew it, some marks, like the Angostura mark, have been running 170-something years. So depending on how viable your enterprise is, your trademarks, your brands can last a very long time. And importantly, all of these forms of intellectual property can form part of your asset base of your company. So if you have to sell the company, you're not just selling the building and the stockpile of products that you have in the warehouse. If you're selling the business, you're selling the registered name and the brand. There are some metrics around the world that actually put a value to brands. I personally use a site called Interbrand, and every year they rank the top 100 global brands, and they put a number value next to the logo, the brand itself, not the company name. So the last time I checked, the Apple brand was worth $488 billion. Not the Apple company. The Apple company might be in the $1 trillion range, but the brand itself. So that's something to consider when you see a brand being floating around sometime. The owners may have changed hands a few times over, but the value of the brand itself can appreciate or depreciate depending on what the new owner does with it. Because some brands, that's why you need to be careful with your branding, especially if you have export ambitions. You need to consider, well, what is this name I'm going to use and how does it scale? How does it translate across different cultures and language barriers? So when you're starting off, perhaps Boise's Electronics might be okay when you're just starting your shop. But when it's time to go global, Boise's Electronics doesn't have the same panache as a Panasonic or something. You have to consider, how is it going to look when I get big? Okay? You have to consider what's the slang in that country, so not just translations. Show of hands, are there any non-Trinis here in the audience? I'm not seeing any. When I say non-Trini, that you don't know Trini slang. Because if I had to ask you guys, I'd like you to open a business selling Tata products. Would you take that venture? Because you know what Tata means. Now, Tata Engineering is a big firm in India. They own Jaguar, they own Land Rover. It's a big company. And once I did meet an engineer from Tata once, and he came up to me after a presentation, and after everybody laughed at that, and he had to ask me, what is wrong with Tata? and I had to explain to him, in this country, it means rubbish. And he said, oh, you didn't know that. You need to know that before you make blunders in trying to get a product. You might have a brilliant product or service, and then you put the wrong name, and you just kill the venture right there because of a name. That would be unfortunate. You need to pay attention in advance, not just translations, but ask about slang. The next area, patents, that's the area I deal with primarily. That deals with inventions or gadgets. Most of the technology that you're wearing right now or have in your purse or your phone, the technology that it's in the car that you drove here with, there are several hundred patents, and just in you getting up this morning to come to here, you've used somebody else's inventions, somebody else's innovation. Unawares, you just know this is modern life. I enjoy these conveniences. Thank you, some bright person who built these things. I don't have to, like my old lecturers had to have a very long stick to point at the board. We had a lecturer like that. I had a lecturer who actually invented, I would say, the first pointer. He took a small torchlight and he put a mask over it with an arrow. And he used that as a pointer. That's the first, it wasn't a laser pointer, it was a torchlight pointer. But he created that himself to not have to use the traditional stick to point at the board. Innovations. I'm solving a problem. And it could be as simple as that. And some of the innovations that we enjoy today have earned their inventors tons of money. And they could be simple things or complex things. So there could be the technology in your car, technology in the medical equipment that you may have used a few months ago that saved your life. Or it could be as simple as the rings around your shoelaces or the pull tabs on the soft drink cans that you enjoyed your beverages from. every time somebody produces one of those things, the royalty on soft drink cans used to be fractions of a cent per can. That's what Coca-Cola used to pay. Because I think the gross royalty, as somebody measured once, was £148,000 a day or something like that to the inventor. Meaning that small, simple things, not necessarily big technology, but if you get in at the right level, with the right kind of volumes, it could be profitable. But it's only profitable if you own the rights. If you didn't own the rights and you said, world, here's what I got, well, then you lose the right to get the rights. Next thing, industrial designs. This would cover the shapes of objects. So not the technology, but how it appears. And this, next to trademarks, this might be another first encounter with many people, for many people with a product. It's the first time they're seeing this thing on the shelf, and depending on what it looks like, you may be drawn to it. If I had more time, I'd give you tons of examples, but it drives, I would say, the things like the perfume industry, the fashion industry, how things look that draw people's eyes. Oh, I like that. Now, if people like it and you don't own the design, well, then everybody else could copy it. That's why the IP system is there. Once you put something on the market and it's accessible by everybody, it's put into the public domain. If you don't secure the rights to these things, anybody may be able to copy it without your permission. It's a permissions game, first come, first serve. So industrial designs would cover shapes of objects. The most famous local example is the chubby bottle. Some of us may have grown up with chubby bottle or seeing chubby bottles and never wondered where did these things come from. Well, SM Jalil created the design, they got ownership of the design, and it stopped everybody else from making a thing looking like a chubby bottle for the duration of the rights. And so essentially they had I would call it the lunch kit market to themselves for 15 years straight. How would you like to have that kind of monopoly on a silver platter? That is the kind of power you get when you acquire some of these intellectual property rights. You get market power because it stops everybody in that jurisdiction from using your creation for whatever the duration is. And for designs, it's a total of 15 years. It's normally 5 years, but you can renew it twice, which means that you have to be attentive to the anniversary dates of these things. There are a few products we know of where the original owner of the brands or the designs failed to renew, and then somebody else picked it up without needing them. So that's one of the dangers that you could face. New plant varieties may not be so applicable to most people here. That's actually better called a plant breeder's right. It's a right given to breeders who put together or crossbreed a new variety of plant to get some characteristics that you all want together. So those of us who shop in the market, and we don't just look for, I want a tomato, you might want a particular type. You may be trying to make a fancy salad, so you're looking for, I need an orange sweet pepper, and I need red cabbage. Well, those are all creations of somebody's breeding activities. What we call eggplant today, and we know today as baigan, melangen, whatever, long, dark purple, there's a reason why they were called eggplants. They used to be the size, shape, and color of eggs, this small. And then years and years of continuous breeding, we got the ones we wanted. Well, some of us wanted purple. I used to grow white melangen. They are striped melangen, or white and purple striped melangen. It depends on what you want or what the customer wants. The breeders will adjust. Those of us who went to hot peppers, you know the arms race is an arms race in hot pepper breeding. You cross the two super hot peppers to get a mega hot pepper until you get to these inedible peppers now. I call them inedible, but people still, they go after it. And that's just as a function of crossbreeding, plant breeders' rights. The last one is what? Geographical indications, and this could apply to many things in Trinidad and Tobago, where we say the characteristics of that product are derived from the geographical region from which they were derived. So far, we've registered Trinidad Montserrat Hills cocoa. So if you know the Grand Couva region in Trinidad, the Montserrat Hills, well, the Montserrat Cocoa Cooperative, they've registered their particular geographic indication to cover their cocoa products, asserting that they taste differently from cocoa or chocolate derived from, let's say, Rio Claro or Tobago or Toco, etc. Or more importantly, from Africa or Ghana. They taste very differently, so those are registered. Recently, we also registered the Trinidad and Tobago steel pan for its reputation as defined by the users who claim that the pans tuned in Trinidad are different or better than pans tuned anywhere else. So there are things that you can attach. It's not just agricultural products. There can be items of handicraft as well, where you attach them to a particular geographical region, saying that the things that came from here are better than similar things that come from elsewhere. That's all it's saying. And it's pretty limited, maybe in most people's experiences. Cocoa, coffee, if you know your coffees, and some people go after the Colombian or high mountain coffees. If you've had the benefit of drinking Jamaica Blue Mountain coffee, you know there's a difference in flavor between that and what they call low mountain coffee. There's actually a distinction that you can actually taste if you're a coffeeist. I'm a chocolatist, so I can taste the difference in chocolates. I don't know, and my friends who are rummists can taste the difference between a Bajan rum, a Jamaican rum, a Guyanese rum, etc. They're different because there are some micro factors in how they're produced, how they're grown, that end up in a flavor. And those are some of the things that you can actually apply for as part of your rights. Now, a lot of these things are not common knowledge, and that's why we encourage people to explore, ask questions so that we can figure out what do you have, what might you be able to pursue. Because the rights are different. In Trinidad, I shouldn't say in Trinidad and Tobago, just to give you some assurance, the system we have in Trinidad and Tobago, the laws, are similar to the laws that you find in other countries in the world, because we are all bound by the World Trade Organization that sets the minimum standards for the types of intellectual property rights we provide. So all of us have to provide the same types of protections, with some micro differences in between in what they cost, and of course how they are applied, okay, and the scope. So it's important. I'm going to get into hopefully a brief section now on what was called the 7 deadly sins of the inventor, because these are mistakes these are not so much IP things, but what you do with your intellectual creations after. All right. Oh, sorry, I was supposed to talk about this first. There's a segment of information where we call patent information, where if the rights were not enforced in your country, you have access to them. That doesn't apply to copyright, because I mentioned to you copyright is universal. So you can't say that somebody didn't apply for their song or their book in Trinidad, therefore I can use it. The Ukrainian author has rights in Trinidad and Tobago automatically, just as you have rights in Ukraine. However, the Ukrainian inventor does not have automatic rights in Trinidad and Tobago unless they applied for it and unless the office granted it. So if you find a patented technology somewhere else and it's not enforced in Trinidad and Tobago, it is not stealing to use it in Trinidad and Tobago. That's the global system. That is actually the crux of the whole generic medicine industry. Generic medicines are essentially medicines made to spec that happen to be on off-patent technologies or expired patents, or patents that were never filed in Trinidad and Tobago. So it's a question we answer all the time to the pharma importers. They're seeking to import some new drug. They will ask us, is so-and-so protected in Trinidad and Tobago? And we tell them yes, no, Yes, but expiring in 2025 August, or expiring in 3031 or 2031. Sorry, these rights only last for 20 years. 20. So that can happen, and that's how you know, can I import or have access to the branded drug or generic version? Some of you who have shopped for drugs know that you may or may not have a choice. The pharmacist may give you a choice. You want the branded one or you want the generic version, which costs a tenth of the branded price. Or in some cases, you may get only one choice, the branded drug, simply because there's a valid patent protecting the drug. These things are territorial. You need to learn how these rights work. And what it means, though, is that even if something is off patent, it doesn't mean that you can get a patent. It just means that you can use it for free. You won't be able to get a patent again because criterion for getting a patent, it has to be brand new in the whole wide world. So if a patent has been granted already, you can't get another patent on the same thing. Okay? Right. Let's make that distinction. It's a rabbit hole, just to warn you. Right. So whatever you are doing, you're trying to solve a problem, you need to be aware of the economics. Yes, he is solving a problem, but not as cheaply as this guy. It's what's called over-engineering. This is a very real issue. Not just over-engineering, but have you overcomplicated and also made your solution too expensive for the market? We've met people who claim that they can solve all credit card fraud, and they bring the stats. Credit card fraud costs the banking system $53 million per year. My solution will eliminate that. Fantastic. What's the cost of implementing your solution? About $1 billion. All right, so the banks will just say, it's all right, we'll just eat the $53 million a year in losses. Thank you very much. Plus, if you make life harder for the client, the customer, because some of us hate lining up behind people who, you mean you don't have $10 cash in? Oh gosh, man. We have some impatient people who want the whole process to go faster. So now what we have, all of us now have cards with chips in it. We don't have to swipe anywhere, just tap. And you're on your way. So the bank is moving towards a faster procedure, faster methodology. So there are things that you have to look at. Are you overcomplicating a process? In IP, dates are very important, and also disclosure. Public disclosure is your enemy. The last thing you want to do is to go and tell the whole world what you're planning to do or what you have, because guys at your stage, some of you who are budding entrepreneurs, you don't have a factory behind you. The guy with the factory behind him, if you disclose prematurely and they see your stuff, they can put it in production in 3 weeks. You can't. Which is why, not saying that Curry did anything wrong here, but sometimes when we see people displaying, that's why we come to these things to tell people, the clock has started running for you, my friend. You need to get going if you haven't acquired the rights as yet. If you recall, if any of you have seen programs like Shark Tank and so on, there are persons who often appear in that, and we've done some research on the contestants, and most of them have had a patent in hand years before they appear in the show. So they're not going on the show blind. They're going on the show with some protection in their back pocket, just in case. Okay? Otherwise, you'll have to move very fast. When I say move very fast, we have a 1-year grace period. If you showed off something to the public yesterday at the display tables, and it's patentable, we will give you 1 year to file that patent. That's the grace period. Okay? Some countries have no grace period. So in some countries, you're dead already, meaning that they could use it in their country. If you're going after anything to do with IP or patents, your invention needs to be brand new in the whole wide world. Right? This shoots down over 9 out of 10 local inventors who come to our office. They come to my office with the thing wrapped up in two black garbage bags, and there's a big reveal. I've invented this. And I just say, oh, that's a so-and-so. How did you know that? And when we show them on Google, they ask us, what version of Google are we using? I say the same one you should have been using before you came here. And then my next question to them is, how long have you been working on this? I mean, I'm trying to gauge how much time have they burnt or wasted reinventing a wheel. The record so far is 13 years. 13 years this fellow was working on something and never came up for air until he made his grand presentation to our office. And then we found it was done since 1946. I say, you're so far behind it, you're decades behind the curve, pal. The world doesn't even want what you have anymore. They've gone ahead past that. It's important that you don't waste your time. And this applies to, we say this applies to academics and postgrad students. They're encouraged to check first before you go and devote 5-7 years of your life reinventing wheels. That's very sad. You need to fully consider the problem. What are you solving? It might seem okay in your head, and we encourage some people, sometimes we have to encourage some people to build a prototype and see if it works. It's not necessary. The persons who examine the patents are scientists. We can tell you if it will work or not, but the persons who are developing the inventions are not always subject matter experts. And some things seem apparent. I'll give you an example. This is a real patent for a real invention. This is an escape device for a burning building, granted in 1879. The way it works is that you strap the helmet onto your head with the parachute, you jump out the building, and you pull the string. The patent office granted this. They say, as far as they're concerned, it will work. The parachute will deploy, your head will reach safely. If you know anything about skydiving, when time you hit terminal velocity, you will separate. Okay, that's a very real issue. So this would not pass OSHA. And this brings me to a very good point. Just because you've invented something doesn't mean that you can put it on the market. If you've created something, you've got intellectual property rights, it's not the right to sell. Intellectual property rights are negative rights. They are the right to stop somebody else from using your creation without your permission, not the right to sell. If you create something like this, you will have to pass OSHA inspection. If you create a new firearm, you'll have to get certain permissions. If you create a new building structure, you might have to pass through Town and Country Planning or Bureau of Standards. There's some other standards that you may have to overcome to put your product on the market. I was speaking to an inventor yesterday, and he's talking to me about getting certification in foreign markets and the headaches that he was up against. So it's not, even though he had a patent in the US, he had to still get his product certified before it could be sold in that market. So it's not always a straightforward success. Marketing. You're creating this thing for who exactly? Because you like it? Or did you check to see if there's a market? No, this is not a joke. There's actually a real patent behind three-legged pantyhose. By the way, it was invented by two women. In case you're wondering, I'm sure a man invented that. No, it's not. Two ladies are listed as the inventors, and they thought it would be a great idea to have an extra one roll up somewhere in your clothes. And if you ladies know women's clothing, you know there's no way you could easily hide that without it bulging in a bad way somewhere. But the idea was simply that you get a run in one leg, you run off to the bathroom, and you roll them out and you're back in business. I don't think they sold any. They got a patent though. That is not a means to an end. Your goal is to sell a product, not to get IP rights. The IP rights are means to an end. Partnerships. We've seen a few of these things happen. You're working with a team. You trust everybody in this team? I have to ask that because we've had people come down to office and we get into the question, are you working with anybody else? You had any help? And then by the way they mention, yeah, I'm working with some fellas, or I'm a student at the university. Then we have to mash the brakes right there. They say, you know you can't apply for this in your name alone. because what they're trying to do is to cut out their partners. And we have seen partnerships break down right in my office, so-called good friends, and that was it. Once money started to run for the product, the friendship fell apart. And so we advise people, if you think you're going to acquire any kind of intellectual property rights, you should vest it in the company, not in individuals. Because if you have issues with the individual and the company is depending on access to that invention, then the company is up a tree. You realize that? So that's important to know. Right? And it's a question we always get asked. We get asked, what do you think of my invention? Will it sell? I say, I can't tell you that. The market will sort you out. What is it worth? You have to do some metrics to get some figures on that. We did some valuation training last year with folks in the banks. That doesn't mean that you can go to the bank now and with your idea and say, I want some equity against this, please. It's not so well developed yet, but we are trying to push them to get to that point. So we just want to encourage you guys to just be mindful of what you've created, when and where you're going. And the final thing I'd add to, I think I may have mentioned in passing, if your invention depends on secret information or secret knowledge, do not be casual with that information. Because people come and ask you either straight, bold-facedly, or in a roundabout manner for your recipe, your measurements, your suppliers. That is secret information for your entity. You need to be mindful of the itinerant people you hire. Even if they're just in the kitchen, you don't just telephone in the secret sauce or stick it at the door. You have to take some steps. How do I keep the secret sauce a secret? Otherwise, you have no more secret recipe anymore. All right, it's as simple as that. So the more popular ones we know of, the Angosturas, the Coca-Colas, the KFCs, they took steps to keep their secret recipes a secret. And there are some ex-secret recipes, like Listerine used to be a secret recipe. It's no longer, because somebody cracked it. You need to know how to respond to people when they claim, I cracked your recipe. Angostura gets that all the time. And how do they respond? Keep trying, cold. Somebody claimed to have published the KFC recipe online. The KFC did not respond. They should not respond. Don't take that kind of bait. And again, just yesterday, one of the exhibitors told me about somebody just asked them for their measurements for their products. I said, no, you don't give away that information. So you need to be appreciative of what it took to get you to where you are, and be appreciative of the value of your know-how. That is sometimes just as valuable as everything else that you have. Right, thank you very much.